Good evening. With the COVID going on, immigration, we just want to update how, if people are working in remote, what are the things that they need to be aware of? If they are on the non-immigrant visa, if they are in the adjustment of status, if they are in a student visa, what are the things that they need to be careful about? We're going to address that. We're going to discuss about the next year H-1B quota. Is it going to be wage-based? Or is it going to be regular as it was before? We're going to discuss about that, and we are going to also discuss if you have aspects, if you have EB2 and EB3, what are the things that you need to do? If you have not filed the adjustment of status, or if you have not filed an I-140, which is a better one, we're going to discuss about it. And if you have already filed the adjustment of status, can you switch to EB2? What are the aspects, what are the things that you need to be careful about? We're going to discuss about that. Of course, last not the least, the EAGLE Act, which removes the discrimination forever from the immigration law, especially in the employment-based. We're going to discuss about it. Emily, as you know that people on H-1B, let's discuss if they are working remotely. So what do they need to be careful about? Can they, let's say for example, I have a job in New York and I want to move to remotely work from my apartment or my home in California. Can I do it if I'm on H-1B, or do the company need to do anything?
Yeah, so in that kind of situation where the work location is changing from the company's office in New York to a new location in California at your home, that would actually require an amended H-1B petition to be filed before you can make that move. So anytime you're working from home, if it's within the same area, the same metropolitan statistical area as the headquarters or the office where your H-1B was filed for, you can work from home without impacting the H-1B. But if your work location changes outside that metropolitan statistical area, we refer to that as the MSA, usually the county. If you're moving outside the county, then an amendment would be required. So most importantly, if your home is moving, if you decide you want to move to a different city and you've been working from home, you need to make sure that amendment is filed to allow you to work from your new home if it's outside that MSA.
Emily, what about for the people who are on adjustment of status, for example? Do they need to do anything? They have an EAD approved. Do they need to do anything on it?
Generally, no. The 485 is based on the offer of employment, and as long as that job offer is still available under the terms and conditions of the labor certification, you don't need to take any action to that. Now, if you're moving your job because the location where you were previously, the office location, is completely gone or completely moved, that might require a supplement J to be filed, and you need to make sure that your 485 has been pending for at least 180 days and your I-140 has been approved, because your green card, that application is based on a specific work location. So it really depends on how the labor certification was filed. Depending on that situation, it may require a supplement J.
What about the people who are on OPT, not STEM extension, they're on OPT? Can they work remotely?
I don't see any issue with that as long as the supervision is there, especially for STEM OPT. That was a big issue that came up a few years ago. They wanted to make sure that if work was going to be at a different location other than the company location, that there would be sufficient supervision to make sure you're actually being trained and learning something while you're working remotely.
What about the people on L2 EAD and H4 EAD? Can they work remotely?
Yes, no restrictions on L2 or H4 EAD. Those are not tied to a specific employer or a specific work location.
Emily, if I'm on H1B, I'm working remotely for, let's say, Coca-Cola company. I also want to work for Pepsi. Can I do that?
That is possible. If you have the time and the energy, because you're not driving and commuting every day, you would need to have the second company file a concurrent H-1B petition that allows you to work for two employers at the same time. Once that's filed, you can begin working for that second company.
It's called concurrently filed H-1B. What about H-4 EADs, though? Can they work concurrently for two different companies?
Absolutely, no problem.
What about the people who have filed for 485 and it's been more than 6 months, they have an EAD? Can they work for two companies at the same time?
Yeah, absolutely. And that second company, as long as you are still being The job offer is still there for the position that you were sponsored for and you're working for that employer. That second job can be any job. I don't think it has to be anything same or similar to the original job. You have an EAD that allows you to work for any employer anywhere, as long as you still have the job offer that supports the 485.
Recently, since the time the COVID has come, we have seen a lot of people working from home, and we have seen an increase in the uptick of the people who are working for two companies at the same time. There is a video that we made on that. Can you work for multiple employers at the same time in a H-1B? Please watch that video that has very good details on it. Emily, what about this rumor that's flying around that next, in March of 2021, we filed for October of 2021, we are also applying the lottery. There is a rumor flying that next year lottery will be on the quota, that is on the wage level. That means that, as people know, that in the prevailing wages we have like wage level 4, wage level 3, wage level 2, wage level 1. So the lottery will depend on, first we'll go to wage level 1, then it'll go to wage level 2, wage level 3, then it will go to wage level 2, and then if there is anything left, it will go to wage level 1. Is that true?
Well, it's true in the fact that the Trump administration actually issued a regulation to make that change, to cause the lottery to basically have H-1B visas be given to highest paid workers. That rule was later put on hold and delayed till the end of this year, so December 31st, 2021. So the rule has not gone away, it's just been delayed. Now, on top of that, there are currently 2 lawsuits pending, one from, I believe, the Humane Society of New York, and the other is from the U.S. Chamber of Commerce. Both are arguing that, number one, this regulation, because it was under the Trump administration, that USCIS director, he was not properly in place. He did not have the authority to actually issue this regulation, so the regulation should be canceled altogether. And then the second argument is that there's nothing in the statute, which is the law passed by Congress, that allows USCIS to decide who gets these visas based on wages. It simply says it should be based on the order that they are received. So they're saying that it violates the statute and it's not consistent with the statute. So we do have, and also let me say that the Biden administration is actually somewhat in support of this rule. When they came out with their immigration plan, the U.S. Citizenship Act of 2021, this is Biden's immigration plan prior to all of this budget reconciliation plan, it included a provision that would allow the Secretary of Labor to decide how to issue these visas. They could use any method they wanted based on what was going on in the market and the economy at the time. So it is something that both Trump and Biden agree on, and businesses are on the opposite side of in trying to fight to get that blocked.
A lot of people are asking questions, Emily, that if I have the EB3 downgrade application pending, and now if I have the EB2 become current, can I use the I-140 approval for the EB2 to go to the EB3 application?
Yeah, there's a lot of moving parts. I mean, technically that is possible if you are still with that employer that sponsored both the EB3 and the EB2. So if you've used AC-1 already to move to another employer, it may not be possible. But assuming that that original job offer is still available, technically it can be done. There's 2 ways to do it. You could interfile the EB2 approval to the pending 485 and ask USCIS to adjudicate the pending 485 in EB2 instead of EB3. Or you can file a second 485 in EB2, assuming that you've been continuing to maintain your underlying non-immigrant status since you filed your first 485. Now, is it a good idea to do either of those things? You have to, number one, realize that this is the government we're dealing with. They're not the most efficient. So anytime you throw a wrench into the system, it's likely going to confuse them and delay things. So trying to interfile that EB2 approval because maybe your EB3 case is still pending, but your EB2 I-140 is approved and you don't want to rely on the pending EB3 anymore, it may actually cause more delay than speeding the process up. Filing a second 485 really puts you in the back of the line behind everybody that filed last year that's still pending. They don't take your existing 485 and apply the process to the new 485 to move you up in line. And so ultimately, whether you get the approval of the green card in EB2 or in EB3, it's the same green card. It does not matter. So whichever way is going to be the fastest, that's the one that's best. Is it going to actually be faster to move back into EB2? Maybe not. I don't think it's a good idea unless there's something possibly going wrong with your EB3.
One thing noted down, Emily said two processes. One is to interfile and also the second one is to refile the entire thing. In the interfiling thing, you must get the EB3 I-140 approved. Otherwise, even if you interfile without the I-140 underlying EB3 I-140 being approved, because that's the basis for your 485, they cannot adjudicate your 485 application. So if you get your underlying EB3 approved anyway, what's the purpose of interfiling? Because EB3 is more forward than EB2. What's the purpose you are doing by interfiling? So that doesn't make any sense at all. Now, if the I-140 is still pending and you're filing an entirely new application, I would not suggest that you do it because one, as Emily was pointing out, it confuses them. And when both 485s are pending at the same time, USCIS is going to force you to withdraw one of the 485 application. That will take a longer time. So at this point of time, though, definitely I would not do interfiling, and I would definitely not do file the entire application out again. Unless there is a fundamental flaw in the previous application, I definitely will not refile the entire application. Emily, if people now are applying for the labor certification, what should they pick, EB2 or EB3?
That's anybody's guess right now. Obviously, EB3 is well advanced of EB2, and we do expect that to continue.
I object to this, Emily. I disagree with Emily on that. In the labor certification, though, I would like to have EB2 only. In the I-140, I would choose EB3. The reason is that if your labor certification is EB2, you can do an I-140 under EB2 or EB3. But if the labor certification is EB3, you cannot do EB2 for that reason. But obviously, once the labor is approved under EB2, what would you pick?
Yeah, right now I would pick EB3. While in a perfect world, I would file both because it's much easier to file two I-140s at the same time and get approved in both versus filing one I-140 now and then maybe 5 years from now filing the second one. Then you've got to deal with 5 years worth of ability to pay and all these crazy processing times with the downgrades and USCIS having to get the labor certification from the other file. It's probably faster to file them both together if you can.
Yeah, you can file both I-140, EB2 and EB3 at the same time, and then you have a ticket for both the things to go. I normally would do that though, rather than, but given a choice though, Emily, where the employer is forcing you to go with EB3 and EB2, what would you do?
Right now, I would go with EB3.
Okay, that's what I would do too, under the current conditions. Now, please don't come back after 1 year or 2 years and tell that, oh, Emily told this, we did it. It's just an estimate, it's just a suggestion that we are making. We can go wrong in this one. That's what, based on the date spread we are looking at, that's what. Any updates on the EAGLE Act, Emily, the act that will remove the per country limit, and most probably that will make the priority dates move almost equal to everybody else, like other country nationals, for Indian nationals and Chinese nationals. Where is the bill at?
So as of now, it has been introduced and it has been referred to the Judiciary Committee in the House. And I think it's got about 62 to 65 co-sponsors. So it's growing just like the Fairness for High-Skilled Immigrants Act did. I don't expect to see any activity on it in the near future simply because all attention is focused on the budget reconciliation process. So we'll have to see what gets included in that from an immigration standpoint around September 15th. That's when we're expecting to see that. Maybe parts of this will be incorporated into that budget process. We just don't know at this point, but I don't expect to see any movement on the EAGLE Act while the budget reconciliation process is underway.
Let's go to live questions. Sudhakar from Facebook is asking question. Does the time spent by the child outside United States, will it be taken off from the CSPA, speaking of Child Service Protective Act, or will it be deducted from the 21 years of age of her? The answer is no, it will not be deducted. Time spent outside the country will not be deducted from the age of the kid. Only time that the priority date, with the I-140 is pending though, that's the time that will be deducted. Questions are coming about, Anu Girish is asking question, what is the recent priority date approval, a PD approval downgrade application in your office? In the past 2-3 weeks though, I mean, we did get a lot of approvals though, and we keep getting it. There are approvals that got in 2012, EB3 also we got approvals in 2012. I think so there may be some 2013, but I don't recall. But 2012, we have seen a lot of approvals. EB2 definitely, most of the cases, a good number of the cases got approved. I wouldn't say most, but good number of the cases got approved. EB3 definitely, the proportion of the amount of cases that we filed as compared to the cases that got approved is comparatively less. If the EB2 approval rating is, let's say for example, maybe 30 to 40%, the EB3 is definitely less, they're definitely less percentage than that of the EB2 though.
CS from YouTube wants to know, the birth certificate is missing the last name of the parents. Is it going to be a problem? It's not necessarily a problem. It's something that can be easily solved by getting affidavits from relatives or family friends that can confirm the names, full names of both parents. So it is something that they'll look at, and you may have to get affidavits for that.
Aris Mallu from YouTube, 2 full-time jobs, are they allowed in EAD? Absolutely, you can. You're speaking about adjustment of status EAD. Yes, you can. You're speaking of H4 EAD. Yes, you can. You're speaking of L2 EAD. Yes, you can. That's all I can think about all the EADs. There are about 78 different methods of EADs, but these EADs, what I mentioned, you can do multiple jobs at the same time.
All right, Sachin from YouTube shares that his 485 status change to new card is being produced today. So congrats for that. We love to hear that.
Thank you very much, Sachin.
Good.
Congrats. Yeah.
Congratulations.
We've been hearing these things very many times, though. That's good, Sachin. I'm happy for you.
Pratusha from YouTube said, we did not file the medicals with the 485. If we want to right now, can we send the medicals without the RFE using the 485 receipt as referenced? So prior to people starting to get those text messages and emails and notifications about these medical RFEs, we would suggest, yes, go ahead and submit the medical through the Interfile process. We have an article on rnlawgroup.com that gives you the details for how to do that. However, right now, because we know USCIS is planning to send RFEs for the medicals, it may be better to wait for the RFE at this point, because it's very possible they might cross in the mail and you might have to get it again to submit it in response to the RFE.
Are you seeing any progress in consular processing for employment-based immigration petition? No, Mahesh, we are not seeing much progress in the employment-based processing, the consular processing. They were delayed even before COVID. Now with COVID, they have an extra excuse to delay it. So definitely, if possible, if you can come here and file a 485, I would do that instead of filing it there outside the country. Ragaswaroop
wants to know if there's any update on the FOIA, which Reddy Neumann requested for the 485 data. This is under the Freedom of Information Act. You have a very good memory. We did request details to find out how many downgrades were filed, how many 485s were filed in October under that visa bulletin, how many were in EB2, how many were in EB3, and lots of other details. Have not received a response from USCIS, so we do not have that data yet, unfortunately.
Sri Harsha has this question. His priority date is June 12th, 2019, EB2. What are the prospects in the next 3 to 4 years? Should I think of downgrading? Um, it's a good investment. That's what I would say, Sri Harsha, that you are going to downgrade. It's a good investment. As Emily pointed out, the longer time it takes, then more paperwork is required to get your EB3 approved. So I would definitely consider, if you think so, you're going to stay here for the next 3 to 4 years, I would definitely consider downgrading and keeping it ready though. There are a lot of moving parts right now. One, we do have this 150,000 extra green cards though. Last time Emily estimated that, she's on the record to estimate that it's going to move to 2012. She was definitely wrong by 3 years. Hopefully so she will be wrong by that time. Again, repeated mistake. So you can even file a 485. But yeah, that's number one thing that you may be looking forward for. The second thing is that the Eagles Act, which Emily has mentioned, has a possibility of passing. There's a different leadership in the House. There's a different leadership in the Senate right now. So sorry, in the House it's the same leadership, but in the Senate it's a different leadership. So we have a good possibilities of getting the Eagle Act out now. If the Eagle Act comes out though, June 12, 2019 for EB2. I'm definitely, EB2 or EB3, I'm definitely expecting that to be current for you. So that's another thing. Then we do have this budget bill, which passed through the Senate and is cruising through very well, is expected to pass through the Senate and House. The only problem there is that will any of the immigration provisions, what kind of immigration provisions will be there? Could there be some last minute amendment? These things can happen. I've seen these things happen. The per country limit and certain other things can be put in, last minute amendment can be put in. So there are a lot of moving parts though. I definitely, if I were you, I would invest the money in downgrading and keeping it ready so that if the things become current, I'm going to file a 485.
Soham from YouTube says, how much distance from the work location is considered working remotely, or when is an amendment needed? So it's not actually based on distance, it's based on what metropolitan statistical area the two work locations fall under. So there's actually a specific list of metropolitan statistical areas. So you look up the first location to see what area it falls under, look up the second location to see if it falls under the same location. If it's the same area, then no amendment is required. If it falls under a different metropolitan statistical area, then an amendment is required.
Is there an exception for a drivable distance, Emily? So what if I fall into different MSA, but it's within 5 miles?
Yeah, I think if it's within a normal commuting distance, usually USCIS will accept that as not requiring an amendment. Amir Tharaj wants to know, I've applied for my I-140 downgrade with premium and got an RFE. Already responded to it 30 days ago, and the case status has not updated, even though we applied for premium. So if it was accepted in premium processing, your employer or their attorney can email the premium processing unit to ask for an update on the case, because it should have been adjudicated within 15 calendar days of them receiving that RFE response. Possible maybe it didn't make it into the file, and maybe your employer needs to submit it again, but the USCIS premium processing unit should be able to respond to that email with an update.
Is it good to file the downgrade right now, or should I wait until October 2021 to file it? I would file it right now. Couple of reasons. One is that you'll be ahead of the game for the I-140. Second, your address where you're going to file the 485 application changes. If you file along with the I-140, it goes to a different address. It may go to different address. There are some things which go to the same address, but sometimes it goes to different address. Definitely what we are also noticing is that the cases that we filed with the I-140 as compared to without the I-140, the cases that filed along with the I-140 are taking long time. The reason I think so, maybe, Emily, is there are 2 less officers who can adjudicate the I-140 and 485 at the same time. There are not many trained officers, because most of the officers are trained in either 485 application or I-140 application. They're not trained in doing both the things, since the packages are going together. It is a little bit confusing for them, because historically they have never received these many kind of downgrade and 485 application, and they don't have a mechanism to handle it. And that's the reason why I would put the downgrade application right now and then file a 485 in October though. A lot of people ask this question that, hey, my I-140 is not approved. I am going to just, my I-140 is not approved. Can I still file the 485 application? Yes. If your priority date is current, you can file the 485. You do not need your I-140 to be approved. If it's been filed, you can definitely use that and file a 485 application.
HBR 1228 filed an EB3 downgrade last October and has tried to upgrade it to premium processing 3 times. He's not gotten any response, not even a rejection notice, and wants to know if this is normal. So it is normal that they don't accept the premium multiple times. We've had many that we've filed 3 times and it's not accepted, but we do normally get that rejection notice. So that is a bit unusual. It's unclear where those rejections are being sent to. Should go back to the attorney if the attorney filed the premium, or it should go to the employer if the employer filed the premium. It is unusual for you not to receive the actual rejection notice.
Asking for a friend, Prem Kumar, the prior date is 2016, current company is in the ad stage, should he change the job now? Tough questions to me. I would, Emily. I don't know when I'm going to file the Perm application. When I would. Prem, you can ask your friend to start negotiating with the previous company to see if they are willing to take, and then maybe he can take a decision instead of on August 16th. Maybe he could take on August 17th. He can take a decision on September 17th. At that point of time, it's very clear whether it will be current. Most probably it will be current. So I would start negotiating, open the discussion with the employer to see what's going on. Question from Krishna from YouTube as this question: downgrading from EB2 to EB3, is payslip needed? I'm assuming if you are not working for the company, if you're not working for the company, you don't need a payslip at all. However, though, there is something called ability to pay. If you're not working, let's say for example, the prevailing wage is $100,000 and you are now filing an EB2 to EB3, if you're not working for the company, the USCIS is looking into, does the company has the ability to pay $100,000 per year? The way they look into is the profits of the company though. There is also another twist to it. What if they file for 10 different people and all of them are not working for the company though? Then it should be, the profit should be $1 million. That's where the problem comes in. If you have a pay slips and W-2, obviously, the job is better. If not, they will look into the income tax returns of the company. If the income tax returns of the company are sufficient enough, then you will be fine. You will get your I-140 approved.
Rum from YouTube has an H-4 extension application pending for the last 6 months and has since renewed his passport because it was expiring in less than a year. And he wants to know, can I interfile the new passport to avoid a shorter I-94? Well, the good thing is it's actually not necessary. USCIS, when they are approving H-4 extensions, does not normally shorten the I-94 due to expiring passport. That's something that CBP does at the port of entry when you travel into the U.S. with a passport that's expiring. So you shouldn't have to take any action related to the new passport.
Vishweshwar Janarkar has this question: what about the distance of 100 miles and it's 1.5 hours to distance? 1.5 hour, what I meant is that. I don't think so that falls in the same MSA. I think so one of the biggest MSA in the world happens to be Dallas-Fort Worth, all the way to Frisco to Fort Worth. It's a very long distance, but it's still not 100 miles. It's less than 100 miles, way less than 100 miles. So if it's 100 miles, 1.5, obviously I can just say you're out. Typically I give them, if it's the same MSA, that's fine. If it's not same MSA, I give a 20 mile, that's the normal thing that I tell people. But if it's anything more than 20 miles, I tell them to contact a lawyer.
Eshe from YouTube has an I-140 approved with company A, and then he moved to company B, filed an I-140 with them, imported that priority date. Now he's got prevailing wage determination going on with company C, and wants to know if he can file the 485 still using the offer from company A. Well, it depends on whether Company A ever withdrew that I-140. If they did not, are they still willing to offer you that position and sign the 485 Supplement J? And are you intending to go back to that company? If the answer to those is yes, then you can file the 485 using Company A's I-140.
Question, what are the restrictions, Jatin has this question, Jindal, from YouTube. What are the restrictions on H4 EAD, job or business? None, zero, zip. The regular restrictions that you have in the US citizen, for example, a guy like me, a lawyer, cannot do surgery operations because I am not licensed. In the same way, I cannot dispense the prescription medicine because I am not a pharmacist. That is regular restrictions that you have on the US citizens. It's nothing special. So same restrictions are for you too. Other than that, everything. Now the only little thing that we say is that don't involve in the weed business. That may or may not be legal for US citizens. For you, it is illegal. That's the only thing that I can think. Anything different than the US citizen, that's the only thing that I can think.
Nick from Facebook has a follow-up question on remote work. He wants to know if his EAD is still pending and it's been more than 180 days since the 485 was filed. Do I still need an H-1B amendment to work from another state? Yes, you do. Because even though you qualify for AC-21, which would allow you to move your green card process to the new location, you still need a way to work in that new location. And if you don't have your EAD yet, that means you're still relying on your H-1B, and that has to be amended.
Questions on the adjustment of status EAD. Can I have two W-2s working for two different companies? Yeah, sure, you can. You absolutely don't have any problem. You have an EAD, you can have two W-2s at the same time. A lot of people ask this question, can I have multiple W-2s? My wife, of course, she's a US citizen right now, but she gets W-2s from 8 different companies. She worked for 8 different companies. Nothing wrong with it. If you are on EAD, you can get that many kind of W-2s too. I mean, especially those people who are in the medical field, they do moonlighting. Yeah, they do get W-2s from different companies. That's perfectly allowed. Same as if you guys want to, we can work for multiple different companies.
Mina from Facebook has the I-797 original copy of the approval that got lost in the mail when it was sent from her employer to her, and she needs to go for stamping for her visa. And she wants to know if she needs to get the original or is a copy sufficient. The good news is with the consulates having access to this PIMS system, the original I-797 approval notice is no longer required. They recommend that you bring a copy, but they are able to verify the validity of your approval and all the details through the PIM system, even if you don't have that original.
Question that comes from Naveen Reddy from YouTube is, what are the eligibility requirements for the downgrade from EB2 to EB3? Now, I just want to elaborate this one though. When we started discussing about the downgrading in September of 2020, there were a lot of speculations. No, EB2 is better than EB3. You can't downgrade using the same labor certification. You can't do as a new application. You cannot get the green card on the downgrade application. Everything has been proven to be wrong. I don't know where these people got all these crazy ideas. We have been filing downgrade applications for many years. Might not be for Indians that much, but to a greater extent to Chinese nationals. Yes, no problem with it. Now, some of the people choose not to downgrade. That's really a bad option though. You're going to get one more, you missed the boat, you're going to get one more chance. In October, if I were you, I would downgrade the application though. Now, to answer your question, Naveen, what are the requirements for the downgrade from EB2 to EB3? As far as the employee is concerned, none. If you are eligible for EB2, you are eligible for EB3. The simple example, what Emily has pointed out one time, is that you have been declared a billionaire. All we need to do is that we have to now declare you as a millionaire. All billionaires are millionaires. Not all millionaires are billionaires, but all billionaires are millionaires. There is a simple thing called ability to pay, where the company has to show they have enough funds to show. If you're already working, you're making more money than that of the prevailing wage, that doesn't come in. If not, they will have to go into the income tax returns. But other than that, though, it's not that hard task to prove. It's not that hard task to prove from EB2 to EB3.
Nag from YouTube wants to know, is there any way to make the Texas Service Center expedite their processing times? Yeah, those are horrible. We do have a template letter for you to send to your congressman to let them know that the Texas Service Center processing times are completely unreasonable. They're not in line with the other service centers. We need to make sure we're not wasting government resources and wasting these green cards. So there's instructions on immigrationgirl.com. It's the most recent posting there. You can follow that template exactly.
We provided at the link bottom.
Perfect.
And we also have provided a draft letter also on the rnlawgroup.com, where you can write a letter to the Ombudsman. The details of them were being provided to you in the link that is provided in there. You can write a letter to the Congressman and the Ombudsman.
RS Malu received 2 biometrics, one for the 485 and another one for the 765. The 765 was filed later after getting the receipt of the 485. Is this common, or do I need to notify USCIS? It is very common. USCIS, I don't know what they're doing. They don't have enough biometric appointments, yet they're scheduling people for triple, double, all these different biometrics. Go ahead and go to it. I would not try notifying USCIS. They'll just tell you to show up to it. But yes, we are seeing that. It's been happening for the last couple of years. It's just a waste of resources.
Emily, I need your input on this one. When do you think so that the travel ban will be lifted for Indians?
I do not have high hopes that it's going to be anytime soon. Rumor today is that the federal government is already planning on extending the mask mandate on when you're on an airplane or a bus or a train. And we've had, we had other travel bans due to COVID in other locations way before the India travel ban happened. All of those are still in place. I'm not seeing it happening anytime in the near future, unfortunately.
A lot of questions with regards to the EAD expedited request, though. In the September, we're expecting they will come with some proposals for the premium processing for the H4 and EAD. That's what they tell. Normally, the government doesn't stick with the time, so that is what I expected. People are normally ask questions. There are a lot of questions on there. Hey, can I do expedited request? Most of these expedited requests are failing, and we don't have any secret formula with us. We used to have a court litigation that did work very good for a while, but then later it did not started working very good. So definitely we don't have any method where we can tell this works, that works, or this doesn't work, that doesn't work. We have really no clue on what works, what doesn't work on the expedited request.
Let's see, Swati has an H-1B with company A and plans to accept an offer from company B. She wants to know, can she start working for company B after the transfer is filed, or should I wait until the approval? You technically are allowed to start working for the new company as soon as the transfer is filed. It's not mandatory to wait for the approval. In some cases, it might be safer to wait for the approval, especially if it's maybe a weak case or if you have any concern that it might be denied. You may want to see if that employer will file in premium processing so you can get the approval in 2 weeks and then know that it's safe to join. The biggest issue is if you join based on the receipt and then the transfer gets denied, it puts you immediately out of status. So we want to avoid that situation.
Questions with regards to the 2020 priority date. When is it expected to be current? Nirupama, if you would have asked this question about probably in March of 2000, February of 2020, I would have told you not in your lifetime. Definitely. Go back, there are records that I said that. I would say that. In the same YouTube, you go back to the old circuit, I said, not in your lifetime. But then things changed. The COVID came in, we got extra green cards that came and fell into our lap, and then the extra green cards are coming in. There are a lot of moving parts at this point of time. So we have to see how the things will move around. Probably we will see in the next 2 to 3 months, especially in the legislation, and also with regards to the priority date movement, you will come to know more. But definitely, I would definitely still plan to be in the long run. It will be a marathon for you. It's not going to be 100 meters run.
Shashidar wants to know if we file both the EB2 and EB3 I-140 applications at the same time, can the employee pay for it instead of the employer? Yes, absolutely. There is no restriction on the employee covering the cost of the I-140 petition or the 485. The only restriction is you cannot pay for the labor certification process. Mina from Facebook wants to know, is Canada or Mexico a better alternative to get the stamping done at this point of time? And if so, which one is better? Well, prior to COVID, both of them were good alternatives to get the stamping done. But because of COVID, they are also operating at very minimal levels, only handling emergency appointments, which means they're only handling appointments for Canadian citizens in Canada and Mexican citizens in Mexico. So if you're not, so they're not entertaining what we call third country nationals at this time.
Questions came out. Charlie is not expecting the filing dates to move next year, as many 485s are pending. No, he said the final action dates are not expected to drastically move. To my knowledge, he did not comment anything on the filing dates, though.
Parth from YouTube wants to know how long I can work from India for a U.S. employer on H-1B. Well, the most important thing to realize is when you're not in the United States, you're not on H-1B. You're not subject to U.S. immigration laws, so no U.S. laws apply to you on that. So it's whatever your country, if assuming you're from India, if an Indian citizen can work in India, that's the limit. You can work there as long as you need to, but U.S. immigration laws do not apply to you.
Second, how much time it's taking for the H-1B extension and premium processing? It's taking about 4 weeks nowadays. Previously it was taking less time, but it's taking about 4 weeks nowadays.
Debashri wants to know, if I need to renew my passport after applying for the 485, how do I inform USCIS about my new passport? There's no requirement to, but if you are called in for an interview, then bring both passports to your interview.
The hacker has given very less information with regards to this child, whether his age is frozen though. I want you to watch because it's only little information you have given. So there is a video that we posted on YouTube. You can watch it. It's called CSPA. You can CSPA and type in Reddy Neumann. You will get the video. It has all the details. But if you are particularly concerned about it, you may want to have a consultation with the lawyers in our office so that we can give you exactly when the age will be frozen for your kid.
Praband has an H-1B transfer that was approved, and he worked for that company for 2 months, and now he wants to go back to the old company and wants to know if that can be done. So assuming that the old H-1B has not expired and has not been withdrawn, and the job offer with the first company is the same job title, salary, work location, all the terms and conditions are the same, you can actually just go back to work for the old employer. No need to file anything with USCIS for that. But if the old H-1B was withdrawn or it has expired, then you've got to have that employer file a transfer back for you.
Force back from YouTube has this question. There's a mismatch of SSN number in immigration documents. Will it cause any problem in getting the green card? No, it will not, because they're going to do the biometrics and that will tell whether you are the real person or not. The other thing is that in the 485 application though, there is a question that they're asked, and also in EAD and other things, have you ever used other names? Try to put all the other names, that mismatched names are there. try to put in there because they want to check their FBI and other background checks to see if you're not a bad guy. Put the names there so that if there is any confusion, you'll be in a good shape.
Noop from Facebook wants to know, if we change the location of the job with the same employer, do we need to file the I-140 one more time? It depends. Is this a permanent change, or is the job offer as it was described on your labor certification still available to you in the future, even if you're changing locations right now? So if that original job that is mentioned on your labor certification is still available to you, then it's not necessary to file a new labor or new I-140. But if your job is actually moving out of state, and it's no longer going to be available at the old location, then it may be necessary for your employer to file a new labor certification and a new I-140. It's not enough just to file a new I-140.
Questions with regards to the birth certificate. I do not have a birth certificate. What do I do? There's a link I provided in there. If you don't have a birth certificate, you should get non-availability certificate. You should also get 2 affidavits. If you don't get the non-availability certificate, you can still file the 485 application with the 2 affidavits. The formats of all those things have been provided though. For those people whose priority date is coming closer though, I strongly recommend contact your lawyer to see if they are willing to do the entire paperwork right now. In our office, what we're doing is that we're offering, even for outside people, if your company allows, we can do the paperwork, make everything ready. And just on September 30th, all we need to do is that push your package to the FedEx. That's it. It's FedEx package done. We just push it to the FedEx. It's already done. That's what we're doing with a lot of clients. We are taking a minimum, a token amount of money right now, not the entire amount of money. When the priority date becomes current, we are charging them the full amount of money and also the filing fees. And then we are filing an application on September 30th though. It's always good to have your application filed earlier, because last time what we saw is that when it comes to October last date as compared to the October 1st week, there's a lot of difference in processing timing. So you can even avoid by making everything ready. So that's the reason why in our office we offer people, make everything ready and file it on October 1st. That's what we're doing. If you want to take our service, you can go to link, you can send an email to info@rnlawgroup.com.
Kalyan's wife is on L1A and also got selected in the second lottery for an H1B, and wants to know, once the H1B is approved, is there a process to move from L1A to H1B, or is it automatically effective? So it depends. If the H1B requests a change of status and that H1B is approved with the change of status, meaning it comes with a new I-94 card, that change is going to automatically happen on October 1st, whether you want it to or not. The way to avoid that happening automatically, if you need more time to make the switch because it's a different employer, is to have the H-1B filed for consular processing. That means that you will activate it by exiting the U.S. and applying for a visa at the consulate and come back in, rather than having it be automatically effective. That gives you the opportunity to select when you want to start working in H-1B status.
Funny Divya from Facebook has, is it suggestible to move from company A to company B? I-140 has been approved for less than 6 months. No, I definitely do not suggest you. The reason is that even if you have a long time left out of the 6 years of H-1B, you never know what the company B is going to do. I definitely will wait until the 6 months has passed before I make a decision on moving to a different company, because a lot of people, they come in the last 3, 6, 9 months and they keep going, I have to move to India or whatever country it may be. My I-140 has not been approved. What do I do? I mean, you can avoid it, just wait for the 6 months. It definitely, you can see, I mean, if your company is going to withdraw after you leave, the question more about is that, will your company withdraw your I-140? Not more about your moving. But I would not like to take a chance at it to see if they would withdraw or not, because my life is dependent on it. So I would not like to. I would wait until the 6 months has passed. After 6 months, you're safe, and then your I-140 porting is yours now at that point of time. Jay Parekh has this question. Does the priority date is considered at the, to adjudicate the 482 application? No, as long as the final action date is current though. Whether it's before or after, if the officer is quick on it, they will adjudicate it. They do not go by the oldest priority date. Whatever comes on their table, if they have it, they will adjudicate it.
Debbie Prasad wants to know if there will be premium processing of the H4 and H4 EAD starting in September. We don't know yet. All we know is that in the spring regulatory agenda, that is on the agenda for them to actually implement premium processing that Congress authorized them to do quite long ago. And it did have a potential start date of September, but we don't know if that's going to be just a notice or a proposed regulation to implement it in September, or if it will be a final rule and it takes effect in September.
Varun has the H-1B stamping until December, until 2022 December. Can I travel to India and come back? Do I need a NIE? If you do not have any children who are born in United States, you are subject to the bar. However, though, if you're planning to go to India and coming back, and if you don't get an NIA letter, there is another shortcut that you can do, is that you will have to spend 14 days outside of India. Some people are choosing, I don't know, Madagascar, not Madagascar, but Mexico and also Sri Lanka. They're going and staying for about 2 weeks there and then coming from there. You can do that, but you must have the passport stamping already, which you said you do. And a lot of these, I see some travel agents are applying kind of just for Indians only, where they'll have all Indian food and Indian things. If you want to go to Mexico, that options are provided by the travel agencies. You can consider if you're really desperate to go. Ayyappan has this question. I-140 has been approved. There is a typo in the I-140, the company's name. Will that be an issue for 485? No, it will not be an issue. You'll be fine because they can verify the information if it's a proper company that you're working with. Not a big issue at all.
Mahesh wants to know why perms that were filed in February are still pending with the DOL, but they're approving March perms left and right. Well, the DOL generally follows first in, first out, but on top of that, each certifying officer kind of has their own time frame. So there may be cases that are still with the certifying officer from February, and other certifying officers have moved on to March cases. I would not expect to see that continue to happen. Usually they're pretty good about sticking with first in, first out, but there are variances among the different officers from time to time.
Question from Prashu from YouTube. Can I file EB2 to EB3 if I have the I-140 approved and NIW? NIWs, you cannot file EB3 with NIWs. NIWs are national interest waivers are only in EB2 though. They're not in EB3. If you want to file an EB3 though, you have to file the Perm labor certification. The entire Perm labor certification. Once the Perm is approved, you definitely can port the date from EB2 to EB3, but you need that Perm labor certification, which, as you already know, that it's going to take approximately anywhere between 10 months to about 1.5 to even up to 2 years to get the Perm approved.
Barath wants to know if USCIS can take 60 days after an RFE is responded to when the case is in premium processing. His has been pending for 45 days and still no decision. So if they don't adjudicate the application or petition within 15 calendar days after they've received the response to the RFE, they have to refund the premium processing filing fee. So they're not necessarily required to do it within 15 days, but premium processing does happen within 15 days, and if they don't approve it in 15 days, they have to send a refund.
Insta-Italian has this question. The people who got text messages and RFEs for the medicals, and if they have responded within the short period of time, do we expect them to get the green card before September 2021? I would say a majority of them definitely should be getting. If they have asked an RFE on medical, that most probably means that there is nothing else left in that case other than the medical. So most probably they will respond. They should be. And there is not much to open and medical. That it shouldn't take much time. You should be getting. I'm expecting them to get the green card before September. At least 90+% of them should be getting before September.
Srini wants to know why the Texas Service Center is so slow in processing. I think it's mostly just due to the high volume of filing that they received last October. When we file an I-140 and 485 together, in employment-based, every single one of those went to the Texas Service Center. We had no choice. But if it's just the 485, then they are filed in 2 different locations for employment-based, depending on where the individual applicant lives. So the reason Texas is so backlogged is because they received a vast majority of the applications. Everything that was filed along with an I-140 had to go to Texas.
There are a couple of other reasons that I want to add is that they're not used to these many I-140s and 485 coming together. And the biggest thing what the USCIS and what we came to know, the problem was not the I-140 or 485, it is the I-944. That was a nightmare form, and believe me, I think it was 18 pages form. And what the USCIS told us was that, what they gave us information was that the people who are inputting the data there have to manually type all the pages information in their system. Oh, I saw them. I went to Texas Service Center. They are machines. They're robots. They type so fast. But still, to input all that information manually, we had to file 944 application, 18-page file, and we have to give all the assets in the country. Even for a 4-year-old kid, we have to give the bank credit score. Where am I going to get this credit score for a 4-year-old kid? We have to give all that information. They have to input those, and that's the reason the entire processing delay we have seen it is that some of the cases took 4 months just to issue a receipt notice.
Manish from YouTube says, Rahul, now I can flip burgers. So that's great. That means you got your green card.
Congrats.
Good job.
Any other questions, Emily?
I think it's about out of time for today. Thank you so much for joining us. Please be back next Tuesday, and don't forget to subscribe to us on either YouTube or Facebook, wherever you're watching, so you get the latest updates. And you can subscribe to our newsletter by going to rnlawgroup.com.
Hey, you can be the Microsoft CEO too. You forgot that.